Good afternoon, everyone, and welcome to the college's presentation on the standard for consent. Thank you for taking the time to attend our presentation. My name is Anya Walsh, and I'm the Registration and Quality Assurance Manager at the college. Before we start, we want to thank you for continuing to follow the Ministry and Public Health guidance on COVID-19. Your continued efforts and commitment to protecting your patients, staff, and the community are greatly appreciated. Today's webinar provides an opportunity to review and discuss the college standard on consent. We will be answering questions at the end of the presentation. We have enabled our Q&A feature, and if you have any questions during the webinar, just type them into the box and we will do our best to answer them. You can also email your questions to the college after today's presentation. There will be a recording of this webinar available on the college website in a few weeks. We will be providing certificates of attendance, and as a reminder, members can record their learning activities in the professional development log, which can be downloaded from our website. I am happy to be joined today by our two special guests, Rebecca Durkin, partner at Steinecke Macura LeBlanc, and Amy Lee, the college's professional practice advisor. We will now begin the presentation. Welcome, Amy and Rebecca.
Thank you,
Thanks,
Anya.
Anya. Thank you. So, Rebecca, this is kind of exciting. I do get a lot of questions regarding consent and what we need to know as practitioners for consent. So I'm going to try to pick your brain so we can kind of go through these documents together, because sometimes when we read them in writing, it's kind of difficult to kind of decipher what information is important and what information we can put into use. So I'm going to start asking questions regarding certain situations that might happen in my clinic, may happen in some of our members' clinics, just to kind of put some of the verbiage in practice. How does that sound?
That sounds great.
Great, cool. So I guess the first thing is the consent to treatment.
Okay.
The consent to treatment and the consent to collect, use, and disclose personal information. So those are two separate things, two separate principles. So the first principle, I guess we'll start with the consent to treatment. How do you, as a practitioner, assess whether a patient is able to consent or not?
Great question, and an important question. And before I dive into that, I just want to confirm what we're showing on the screen is a copy of the college's standard for consent. So everything that Amy and I talk about today is really going to be flowing from this document, which is on the college website. So Amy, your question as to, how do you assess? If we can turn to the next slide, you have hit on, Amy, the first principle that's set out in this standard. Basically, members are expected to assess whether or not their patient is able to consent to treatment. I'm going to show you the two-part test, but just before we leave this slide, this basically sets out what we're going to talk about today. These are not just pulled out of thin air. These principles are set out in that document. So for anyone watching today, you can go to the document. It's going to speak to that. So if we could turn to the next slide, I'm going to be able to answer Amy's question, namely, how do you assess? And basically what is expected, not just from the college, but legally. The law in Ontario is that health professionals can only provide treatment if they receive consent. And they have to ensure that the patient, is capable of providing consent. And the test is, we've set out here, that the patient, is able to understand the nature of the treatment. So what body parts will be touched, what will be involved in the treatment, what are the possible outcomes of that treatment, and also, is the person able to understand what will happen if they decide not to have the treatment? So this really isn't the informed consent process. This is just, as a practitioner, determining, am I able to trust? Am I able to receive consent from this person specifically? Are they equipped to provide consent or not. So that's sort of the two-part test, Amy, that you as a practitioner will need to go through to reassure yourself that the person is capable of providing consent.
Great, thank you. So when do we obtain written consent? Is this a good time to answer any questions the patient might have about the treatment?
So what is important to remember, you use the term written consent. And I can let you know that the courts, that the legislation, the statutes don't mandate a written consent. They mandate informed consent. But this college has stipulated that in certain situations, you must have written consent. And the reason behind this is that you are expected to always provide evidence that you did in fact obtain consent. Remember, all of this is to ensure that the patient's interests are at the forefront. And it also provides you as a practitioner with evidence, with proof that you only provided treatment after receiving consent, that you only provided treatment to a person who was capable of providing consent. So obtaining the written consent from a timing perspective is going to be crucial at the outset, before the treatment is provided. So you've gone through the issues, you've gone through the risks, and we're going to break that down a little more. But I would recommend, and the college's standard is great to breaking this down, is that when you are assessing whether or not the person is capable of consent, that you go through the consent process and you ensure that the necessary information is being provided. And that can then be documented. So it'll be written by your documentation, or, as we're going to talk about, it could be through a written consent form.
Great, thank you. So how do we figure out whether or not this person is capable of consent?
Great question. Let's go to there. Thank you. Someone's reading my mind. This slide speaks to that. And it's really important to remember that in Ontario, there is no minimum age of consent. So some children will be capable of providing consent. They will be able to understand the nature of the treatment. They will be able to understand the outcomes and what will happen if they don't receive that treatment. So some children, and you as a practitioner are going to want to have that discussion with the patient. Some children will be able to provide consent. Some children will not. So you got to be mindful. Don't look for a certain age. Don't be, if the person has language difficulties, that does not mean they're not capable. Also, it's important to remember that if a patient has a mental disorder or suffers from a mental disorder, that does not automatically mean that they're not capable to provide consent. And the final piece of the puzzle, and the courts have confirmed this, is that sometimes you will be capable to consent for one treatment, but not another. Sometimes your consent will come in and out. So one day you will be capable, one day you will not. So this really drives home to the practitioner. It's important that you are mindful and you are aware and have those discussions with your patient to see if they're capable.
Yeah, I totally agree with you. The idea of having open communication is very, very important. Sometimes we have children, like let's say 15 years old, they come into the office and they want to try acupuncture. However, they do not have the consent of their parent because they think that they're a minor, that they cannot consent to a treatment. So I really like that we've touched on this point, how we assess. How do we make sure that this person has consent and if they can give their own consent? And this happens vice versa as well. So let's say a 15-year-old teenager comes in with their parent, and their parent really, really wants them to have acupuncture, but they said, no, I don't want needles. I don't want needles at all. I'm deathly afraid of needles. So you've already heard from your patient, who is the 15-year-old, that they do not consent to treatment. So we sort of need to make sure that we have those conversations with their parents, and as well as the substitute decision maker.
That's a great point, Amy.
So bringing up the substitute decision maker, we're still talking about principle 1. Can you tell me a little bit about what a substitute decision maker does, is, who?
Sure. So as the standard sets out, and as the law in Ontario sets out, you as a practitioner have to assess whether or not that person is capable to consent. So before you even get into the full consent discussion, you have to say, are they capable? If they are not capable because of age, other capacity concerns, then what you need to do is you need to turn to the substitute decision maker and obtain consent from that person. So in Ontario, the legislation, the law sets out that simply because you're a person that's not capable to consent, you can still get treatment, but that consent has to be provided by someone else. Because this makes sense. As a practitioner, you simply wouldn't be able to see a child and say, because you're a child, a young child, because you're not capable, I'm able to do whatever I want with you. Of course not. That wouldn't make sense. So what makes sense is that as a practitioner, if you are presented with a patient that cannot consent, you will turn to the SDM, the substitute decision maker. And what we have before you, Amy, is the list. It's a sort of a hierarchy in Ontario as to who you as a practitioner should go to obtain consent. So again, substitute decision makers only are needed when the patient is not capable to consent. So sometimes you will never need a substitute decision maker because the patient can consent. But if they don't, what you're going to do is you're going to be mindful of this hierarchy and see who is highest on this hierarchy to provide consent. So quite quickly, the first person at the top of the hierarchy, which in my experience is very rarely present, is someone appointed by the courts called a public guardian. So a lot of people never get to that. But if a public guardian has been appointed for the person, you as a practitioner would go to the public guardian to obtain consent for treatment. If the public guardian is not present or relevant, the next level on the hierarchy is a person who has a power of attorney for personal care. And this is a document that the patient would have signed while capable, advising that the attorney, and that's the term, the attorney has the authority to provide consent. So you will ask, and that's what, are you the power of attorney for personal care? If so, can I see that document and have that in my records? Great. But a lot of people don't have a power of attorney for personal care. So the next level is someone who is appointed by the Consent and Capacity Board. And that's usually when there's a warring of family members as to who should be the SDM. Again, not always present. In my experience, and probably in your experience, Amy, what you're looking at is probably at list 4, 5, 6, 7, and 8. So you're probably looking at a spouse or a partner. They are next highest. So if the patient has a spouse or a partner, they are the SDM if the patient is not capable. If the next level is an adult, child, or parent. And a note, it says a custodial parent, because sometimes if the parents have separated, one parent might have custody, one might not. And so it's important that you are mindful as a practitioner, you need to obtain consent from the custodial parent. If that isn't present, then you go down the next list. So you can see it's a staged approach. In my experience, you're probably only going to start at level 4, but those 1, 2, 3 levels do exist.
And sometimes they do happen. I mean, certainly it is confusing, but I think sometimes when the patient actually has an SDM, they are quite forward with that information.
Good.
They will tell you that you need to obtain this before we start treatment, before we set up our initial consultation, before I sign anything. But this kind of brings me to payments. So like perhaps the SDM is appointed by the court and they're not a family member. Would they be responsible for the payment, or would the patient take care of the payment?
So usually and practically, if a court has appointed a guardian for someone for health matters, there will also be a guardian for financial matters. So in my experience, what would usually occur is that when the guardian consents to the treatment, they will be made aware of in advance and should be provided the cost. And the guardian will say, we will pay for that. Or the guardian will say to you as the practitioner, no, we are not responsible for that. You will collect that directly from the patient. But in my experience, if the courts have appointed a guardian, it indicates a true lack of capacity, so that the guardian will also be provided for the financial matters. But that's an important thing from a business perspective. As a practitioner, you will want to clarify, because we're going to talk about that. Consent talks about treatment. Consent talks about information, but consent also can talk about costs, that it's really important as a practitioner to ensure that you are providing either to the patient or the SDM what the cost of this treatment is going to be in advance, so that that patient or SDM can be fully informed before making a decision.
And that's a really great point as far as having the full information, the communication when it comes to consent, right? Because you're consenting to the treatment, but you're also consenting to the cost of the treatment.
Exactly.
So I think when we obtain consent, all of this information needs to be available readily and specifically advertised and in place at all times. Okay, great. What happens if the member doesn't have their SDM name and contact information on file with them when they come in?
Well, if we could turn to the next slide, thank you. The standard that the college put out has quite properly said that practitioners, if you are going to obtain consent from an SDM, a substitute decision maker, it's really important from a record keeping perspective, you have the substitute decision maker's name and contact information. Now, sometimes if a patient comes in and suddenly you realize they're not capable to consent, you're going to have to seek out whether or not there is a substitute decision maker. So you would not provide consent until you obtain the contact information or able to speak to the SDM. So if you don't have that information on file right then and there, that's usually an indicator that you weren't aware that there was an SDM. But if you are aware there's an SDM, a substitute decision maker, it's imperative from a record keeping perspective that you have that contact information, because not only is that in the best interest of the patient, but again, it provides evidence for you as a practitioner that if challenged by the patient, by the college, by someone else, no, you have evidence that you obtained consent from this person who can be located at this phone number. You're going to see the importance of record keeping. There's a separate standard on record keeping, but with consent, not just the disclosure information, but dealing with consent to treatment, there is a real need to ensure that members are documenting properly, because that again is in the best interest of the patient, but it also provides you, members of the profession, with evidence that you have followed the standard.
Great, thank you. Here's a really silly question. I know we're talking a lot about this substitute decision maker. What happens when the patient insists on having treatment, but does not have their proper documentation from their SDM?
Okay, so in that situation, and again, practitioners are going to be expected to use common sense. So in this situation, if a patient shows up, requires treatment, tells you that they have a substitute decision maker, tells you that I myself am not capable to consent, but I have a substitute decision maker. And if they do not provide you with sufficient documentation, so if they don't have a power of attorney for personal care, my advice would be to contact, to obtain, ask the patient, can you give me the name of your substitute decision maker? Can you give me the contact information? And then ideally call that substitute decision maker, explain the situation. The substitute decision maker might say, no, I do not consent. And in that sort of situation, even though the patient says that they want it, if that patient is not capable of consenting to the treatment, they might say they want it, but again, back to that first principle we looked at, if they're not capable to consent, then you as a practitioner are not legally permitted to touch or treat that person. If you provided treatment without consent from the SDM, and you know you can't obtain it from the patient, you are treating without consent. And permission is different than consent. So it's really important that you're mindful of that.
I'm really glad we covered this, because there's so many gray areas when patients come in, when they make appointments and they show up for initial assessments. Consent forms are all there, but it's a really nice way to sort of break down who can actually consent and why this information is important for our members. So moving along, what must the patient understand before the treatment is provided?
So let's go to the next slide, because this is going to touch on our second principle. So we've been talking about whether or not a patient is capable to consent. We've talked about what you as a practitioner should do when you determine that a person is not capable and you have to go to another person to obtain consent. But in the situation where the patient is either capable of consenting or you've gone to a substitute decision maker, the courts, the college, and the legislation is clear that you have to provide certain information to the patient in order to obtain consent to treat, okay? And this can be quite technical. So it's important to remember the first portion of our discussion was just talking about whether or not the person is even capable of giving consent. This talks about the actual consent you need. And the courts and the legislation make it quite clear that certain information must be provided to the patient before they can actually consent. So they might say, no, I don't care. Just treat me. I don't care. And it's important for you as a practitioner to say, no, I cannot treat you until I obtain informed consent. And you can't give me informed consent until I share some information with you. So it's really important we break this down, what needs to be shared. And it's also important to remember that the concept of giving consent is continuous. It's not that you give informed consent on January 1st and say, great, I've done that, and now I can treat you over the next 20 years without any problems. No, the courts have said, as a practitioner, you need to constantly assess whether or not the person's capable to consent to treatment, and if another informed consent bundle needs to be provided because of changes in the treatment or changes in the situation.
Right. And I think as a member of this college, I've had patients that just say, I just want treatment. I don't care about the paperwork. I just want you to fix me. Please just fix me. Right.
Yeah.
And we have to sit down and explain to them why this piece of paper or this document is so important, why they need to know exactly what we're doing and what we're going to be providing for them.
Exactly. And if we go to the next slide, it really it's setting out the components of informed consent. And I can let you know, this is not a list created by the college. This is a list set out in legislation. So this applies to every health professional in Ontario. Every health professional in Ontario must go through this dialogue with their patient before treatment can begin. So, as we've seen, you need to describe the nature of the treatment. What's going to happen? What body parts are going to be touched? Okay, that'll ensure that the patient is informed. What benefits can they expect? What are the risks? What are the material risks of the treatment? Is there a risk of bruising? Is there a risk of lung puncture? What are the material risks? Not, one in a gazillion. What are the material risks to this treatment? Because most treatments, of course, have certain risks. Are there any side effects? You'll want to disclose that in advance. Are there other options? And what will likely happen if they don't have the treatment? So I'm going to pause there. All of that has to be disclosed in advance. And the rationale is that the patient has to be fully informed. You can see where that word comes from. Fully informed and aware before they consent. Because you can understand the concerns if a practitioner did not provide this information to the patient. They said yes to the treatment, and then they'd suffered significant health consequences. And they said, I didn't know that this could happen. That's not in the interest of the patient. So all of this must be provided before the practitioner can be satisfied they have consent. The last bullet the college has provided as a reminder and as a tool to assist members. The last bullet talks about cost, and that's not set out in legislation. But what the college has done is that they have included this here to remind members that it can be an act of professional misconduct sometimes to treat without disclosing costs. And because, of course, some of the treatment costs of this profession can be quite expensive. But irrespective of the cost, it is imperative that members disclose the cost before they start treatment, because otherwise they really are making themselves vulnerable to a complaint.
Right. So back to the patient providing consent. What if they've already provided you with their consent, but they still have questions? They're still unsure, but they've signed the document anyway.
Okay. So back to the legislation, because that makes things actually easy. The legislation states that, again, informed consent is not truly provided unless the practitioner has answered the questions of the patient. So if the member has gone through all of these issues and then hands the consent form to the patient to sign, and the member signs but says, the patient signs but says, but I have a bunch of other questions.
That happens.
You as a practitioner need to be aware that even though the patient has signed that, consent hasn't been fully obtained. So the signature on the form does not crystallize the consent. Consent is crystallized once you've gone through these issues, once you've answered any questions of the patient. Once that is finished, then you have consent. So it would be my advice is do not even give the form to the patient until you've gone through these issues. You've asked the patient, do you have any questions? And if the patient says no, or if the patient does have questions and you're able to answer them, that's when you provide the form, because that is when the patient is fully informed to provide the consent.
Okay, great. That makes a lot of sense. So I have some questions about consent. What's the difference between expressed consent and implied consent?
Great. Very important, and especially when we talk a little further on about sensitive body parts. Expressed consent is when the patient expressly, directly consents to the treatment. So it could either be by indicating they've signed the form. It could be by saying, yes, Amy, I do consent. I am providing you with informed consent, and then Amy can write that in the chart, informed consent provided. That's direct. It's not ambiguous. It is very clear to anyone who is in the room, if there was anyone in the room, that consent has been provided. But of course, healthcare is a little more nuanced. Healthcare can be provided in certain situations, and the dialogue between a member and a patient is sometimes not as direct. So implied consent, the courts have confirmed that in certain situations, a practitioner can rely upon implied consent. So an example would be, if the practitioner says, okay, can you get up on the table, and I will start the acupuncture treatment. If the patient, after providing the informed consent, gets up on the table, the practitioner can take that as yes, the patient's getting ready for treatment. If a patient, if during treatment, the member asks, I'm not going, can I touch a certain body part? Is it okay if I touch a certain body part here? Maybe not a sensitive body part, but could I disrobe your arm to provide? And the patient just nods, or doesn't say anything expressly, or takes off the robe herself to expose the arm. That's implied consent. Okay, so it's not perhaps in writing exactly, it's not verbalized, but through body actions, the practitioner is satisfied that they do have the consent of the patient to proceed. But as we note on this slide, it's not always appropriate or wise to rely on informed consent. There are going to be certain situations where a practitioner cannot state, I relied on implied consent. The college is making it very clear that in certain situations, it's not in the patient's interest to simply state you relied on implied consent. You can see that express consent is ideal because it's not ambiguous. It is much more clear. So from a legal perspective, when you can, obtaining express consent is probably ideal. But there are certain situations where you should not rely on implied consent.
And when is that? Can you give me an example of when implied consent is not appropriate?
Sure. It's going to be when the risk of the treatment is higher than the usual. So, the scenario that I described, can I remove the draping to massage, let's say, your upper arm? Okay, and if the patient just nods, or the patient takes off the sheet, or the patient doesn't say anything and doesn't object to you proceeding after asking or saying you're going to do that, there's very little risk in that level of treatment. Contrast that to a patient being on the table in a state of undress, and the practitioner says, I am going to remove the robe and expose your chest. And the patient doesn't say anything, and the member says, well, I relied upon that as implied consent. Well, the risk to the patient of being exposed is much higher.
Right.
So that sort of situation, a practitioner cannot say, oh, she consented because she didn't say anything. When you're involving sensitive body parts, when you're dealing with riskier treatments, and acupuncture, remember, is a controlled act, so it's inherently a risky treatment. It would not be in the best interest of the patient or the member to rely upon implied consent. And as we're going to talk about, there's certain situations where the college has mandated that you must obtain written, expressed consent before certain treatments can be provided.
Okay, that's a good way to clarify it. So when a patient gives their health history, can I assume that they are consenting to an assessment?
Yes, that would be a great example. So if someone comes to your clinic and they provide you with their health history, that in and of itself is an indicator that they are voluntarily coming forth, and you as a practitioner can listen to that information. You can rely upon that information. So that would be a great example, sort of an implied consent. Again, not highly risky. It's just kind of a usual course of healthcare treatment. So that would be sufficient. You wouldn't need to say, oh, no. I need to provide you with, you need to provide written informed consent before you provide me with your health history information. That wouldn't make sense practically.
Right. Right.
So that's a great example.
Okay. So now that we've sort of established consent in the beginning, why is it important to obtain informed consent before and throughout the treatment?
Because it's in the interest of the patient. You always need to remember that the interest of the patient has to be at the forefront. So it's really important to the patient before, again, as we've talked about, before any treatment occurs, that they are informed of all of those issues. And so if things change, if during the course, if it was anticipated to be a 6-month treatment plan and situations change, perhaps a different treatment plan, perhaps different body parts, that's a change, and that would require you to go back and get new consent. Sometimes you might want to have someone present, a student or another practitioner present in the room. That, for me, would be an indicator, okay, I'm going to come back to you, patient, because it's in your interest. I need to make sure that you're okay with this, that you consent. And if you view it that way, if you view it that this is in the interest of the patient, whenever there is any change, whenever there is anything that could cause the patient some questions, you're going to go back and you're going to revisit and see if the informed consent needs to be changed. So that's why we say sometimes, if clearly it has to happen before treatment occurs, but throughout the treatment, you're going to want to touch base. Has anything changed? Do you have any questions? Have you any questions since the last treatment? Let's go through that. And I would suggest, as a practitioner, it's always good to touch base with your patient and ask, do you have any questions? Remember, this is the informed consent you provided on January 1. We haven't changed anything, but do you have any questions? So it really gets back to acting in the patient interest. Informed consent at the outset and throughout is in the patient's interest. So you always want to make sure that you're addressing that.
Okay. So with the next slide, I just wanted to review the consent throughout the treatment is important when you want to ask if it's okay for another person to be in the room. If the member wants to adjust the treatment in any way that exchanges the expected benefits, risks, or side effects. And then the last one is if the member wants to start a new form of treatment. So that communication line is always open for the patient to ask questions.
Exactly.
Perfect. Okay, so with the next slide, what are the main factors that apply if the member needs to treat or assess a patient without consent?
Okay, so the legislation and the courts have clarified that there are very few and rare situations where you as a practitioner can treat without getting consent. Okay, so we talked a lot about consent, no touching, nothing before you obtain informed consent. But the courts and the legislature have recognized that in certain situations, emergency situations, it would not make sense for the practitioner to have to wait to get consent before they treat. So the scenarios that, or the factors that are set out here are again set out from legislation. And so if you as a practitioner have tried to communicate, but they cannot. If you have to go and wait and get consent from someone else, it would cause prolonged suffering. It could put the patient's at risk, and there's no reason to believe that the patient does not want the treatment. Now, this should not be relied upon for usual acupuncture treatment or any other form. I'd say this would be more in the situation, again, emergency situation, if a patient before you had a heart attack, if a patient had a stroke, and it required you to touch them, it required you to perhaps apply treatment, perhaps CPR. That's what this is really intending to do. It's not intended as a route to bypass the usual informed consent treatment route. So yes, this exists. There are situations where members can provide emergency treatment, but my advice to practitioners is that this should not be relied upon to provide usual treatment, because that, again, would not be in the interest of the patient.
So let's say in our practice, we send out, it's an electronic file, and we send out all of the forms and intake forms ahead of time, and the consent form is included. Is it appropriate to ask the patient to sign a consent form before their treatment?
So I think if we go to the next slide, I will start by saying I know this is a practice that is usually done. However, as we have just spoken about, giving a patient a form to sign and having them sign it doesn't mean you have informed consent. That the form isn't the informed consent. The dialogue is the informed consent. So if you give a patient a form to fill out in advance and they come back and they've signed, "I consent to treatment," you can't rely on that, because clearly that would have occurred before the discussion of the nature of the treatment, the risks, answering any questions, right? So I see a lot of regulated health professionals relying on this form saying, "Well, I have consent." And I'm saying, well, that was signed before you met the patient. That was signed before you had the dialogue. That was signed before the patient had any questions and you could answer them. So it's not consent. So it's really important that members recognize this, that a signed form, which is great evidence of the dialogue, is not informed consent itself. All it is evidence. And if it comes out that you gave this to your patient before that dialogue occurred, it's useless. It's worthless. You cannot rely upon that for informed consent.
Okay. What does the consent form need to have on it?
Sure. If we go to the next slide, the consent to treatment form is and again, ideally this would be signed after the dialogue between the member and the patient. It should be easy to understand. It will be worthless if it is a confusing document written, if it looks like it was written by a lawyer with too many legal words and long words. If the patient can't understand it, it's going to be worthless. So you want to make sure it's easily understood. Again, you want to ensure that it reflects the fact that the patient signed it after that dialogue occurred, after they had the opportunity to ask any questions. Okay. Ideally, it'll include the nature of the treatment. So you may want to include in there, this will be the nature of the treatment, because that again provides some evidence of what the patient is going to receive. And it again provides evidence for you as a practitioner that this is what was agreed upon. If there's a disagreement down the road, you can point to this and say, no, we filled this out together when we had our informed consent discussion, and you can see we inserted what the nature of the treatment. Another example situation that the college provides, which I think is a great practical, is that you might want to include in that whether or not the patient would consent to having treatment either from a student or be supervised by a student. Again, that's a great practical approach if that's part of your practice, because if you go through these components, and as we're going to see, the college actually has a template on its website. It's ensuring that the patient is informed. It's putting the interests of the patient at the forefront. My advice to you, members of the profession, is do not view this as sort of a legal protection document. That shouldn't be the forefront. Yes, it can provide legal protection when it's proper, but the purpose and intent of this form should really be to educate and inform and reassure the patient. And if you can do that, if the patient can read it, if they can understand it, if they know what's going to happen after they sign this form, then you've put the interest of the patient first.
Okay. And we can find all of this information on the college website. There is
Yes,
a template that is
if you look, thank you. There you go. If you go on the website under regulations, you'll see a clicky there for guidelines, and there you go. The college has provided that for members to review.
So I'd like to talk about sensitive areas. So I want to give you an example just because this is something that as an acupuncturist I treat quite often. Let's say a patient is coming in for sciatica. Sciatica is pain on the lower back that travels into the gluteal area and travels down the leg. And I specifically think that this is a very sensitive area because it goes right into the glutes. So how would I get expressed or written consent for this situation?
So I'm going to start, Amy, by saying that the legislature agrees with you. The legislature agrees with you that there are certain body parts that are inherently sensitive, and that the buttocks, that's how it's phrased in the statute. I mean, the buttocks, I would say area even, is identified as a sensitive area. So the upper and inner thigh, the buttocks, penis, vagina, and the breast and chest walls. These are not areas that the college just picked out of a hat. These are the areas that the Ontario government has identified that if they are touched in a sexual manner, it would instantly result in a finding of sexual abuse and instantly result in revocation. So what the legislature has done, what the college has done to assist patients and its members is to say, okay, because these are inherently sensitive treatment areas, what we're going to do is we are going to require our members to, as part of the informed consent discussion, so the discussion that we've been talking about all along, as part of that discussion, what we're going to say is if the proposed treatment does involve any of these body parts, right, that a special form needs to be signed by the patient. And again, this is to ensure that the patient is fully informed and aware. And the college has, I would suggest, quite wisely come to the determination that if the patient is given a specific form and it's set out expressly what body parts are going to be touched, some of these sensitive body parts, and then they sign, it's ensuring that the patient is informed. It also provides evidence for the member that if during the course of treatment a patient suggests, why are you touching my buttocks? The member can say, well, remember we had that discussion and here's the form that you signed where we agreed that because of your sciatic or because of your specific health needs, you consented to having treatment in that area. So you can see how this requirement on the part of the college helps not just the patient, but also helps the members. So the college, again, has said that at the outset of any touching on any of these body parts, you have to get expressed written consent, and that would be included in the patient chart.
Okay, great. So should this always be written?
Yes. Yes. So, well, first of all, it has to be written. At the outset, it has to be written. But if we could turn to the next slide, these are the reminders as part of that written. So yes, it has to be written. But again, what we talked about earlier, the form in and of itself is not the consent. What the consent is the dialogue, is the discussion. And the written consent form, which is required at the outset of that treatment, of those body parts, what that does, it just represents, it reflects evidence that that dialogue occurred. Okay, so the reminders here, and again, I'm mindful of time, but just because sensitive body parts are so important to be mindful of, the legislature, the courts have a zero, and the college have a zero tolerance approach on sexual abuse. And sexual abuse, more often than not, results in touching on sensitive body parts. So you can these reminders from the college are reminding members you have to advise generally, not just on this, but generally tell patients what body parts you're going to be touching, because that'll inform them. Okay, if you are going to be touching or proposing to touch one of the sensitive areas, you have to provide extra care in explaining what will be touched, how it will be touched, when it will be exposed from the draping, okay? The patient deserves that. You should also remind the patient that if a sensitive body part will be part of the treatment, it will be exposed for as little as possible. I've had cases with other professions where unfortunately women have been treated in the breast area, the breast was exposed, and then it was left exposed for the whole treatment. And you can imagine how that made the patient feel. So you have to ensure that it's not exposed for very long. You might want to consider culture. That may approach how you discuss this, but again, irrespective of your culture, irrespective of your gender, these rules would apply. And again, the last bullet there, if the patient does consent to being treated on a sensitive body part, the college mandates that that special form is filled in. It does not have to be repeated. This college is not mandating that that form has to be signed after before every appointment. But if a change occurs, if a different body part needs to be touched, then you would be required to have another one signed.
Okay, great. So speaking of the signature of the receiving consent, does the patient have the right to withdraw consent at any time?
Great question. If we go to the next slide, there we go. This again is not something created by the college. This is set out in legislation. This applies to all health professionals in Ontario. And the law is clear. A patient, after giving informed consent, can withdraw consent at any point in time. A member can't say, no, I need to finish because you provided informed consent. That is not patient-centered care. So you need to be mindful that if the patient withdraws consent at any point in time, or if the patient's not capable, and the substitute decision maker withdraws consent, the practitioner no longer has the legal authority to treat because that informed consent, which allowed them to treat, has been taken away. Okay, so it's very important that members this is not just a ticket that you hand in and then it stays forever. This is a living issue. This is why it's a bit of a dialogue. This can be withdrawn at any point in time. And there isn't going to necessarily be a form to withdraw consent.
Right.
So my advice is that if a patient says, you know what, I don't want that treatment anymore, of course, you might want to ask, is there a problem? Was there a reason why? You can ask that. The patient might not want to provide that information, but you can ask, of course, but you'll document that. Saying, you know, on October 30th, patient X decided to withdraw treatment of a certain body part or decided to withdraw a certain treatment. And you would just document that. Back to record keeping. You want that your record to reflect what was discussed and what occurred at each appointment.
Perfect. That's great information. For our members, what is the Personal Health Information Protection Act?
Okay, so now we're on to Principle 5, the fifth principle of the standard. And the first four principles talked about consent to treatment, okay? Principle 5 talks about consent to use, disclose, or share patient information, okay? So the Personal Health Information Protection Act is a piece of legislation. Again, it applies to all health professionals in Ontario. And it sets out how health professionals, such as TCM practitioners and acupuncturists, how they are permitted to collect, use, or disclose patient personal health information.
So can you give me an example of personal health information?
Sure, there we go. Let's go to our next slide. Here are some examples. I will start from a legal perspective, from an advice perspective, is if you're a practitioner, you should really consider almost everything the patient tells you as personal health information. Assume that everything almost is personal health information because that will mitigate the risk, okay?
Right.
But it could be the name. It could be the treatment provided. It could be situations of observations taken during the appointment. It could be information about their health care coverage or the name of the substitute decision maker. So there really is, the definition of personal health information is intentionally wide to protect patient information. And this is a reflection that personal health information is personal and that there is a lot of sensitivity around personal health information. So practitioners should assume that any information that they receive from their patient or filled out on forms is considered personal health information.
Okay, great. And why is this document important? The document of consent to collect, use, disclose personal health information.
So the Personal Health Information Protection Act does basically state to health professionals, you need to ensure that you only collect, use, and disclose personal health information that you need. So if we could go to the next slide, what usually occurs, and I believe this is set out in the college template, is that the member is going to want clarity on what information they can collect, what information can they use, and what can they disclose. And you can see how important that will be, because it gives, obviously, the patient control, and it instructs the practitioner on what they can use, what can they use, what can they disclose. Remember, treat personal health information with a lot of sensitivity. So it's really important, this document of consent to disclose or consent to share will be very important for the practitioner.
Okay, so let's say you have a patient that's coming in and they haven't told their family doctor that they are seeking acupuncture. Do they need to disclose this information?
So essentially, it will depend, and I don't mean to sound like a lawyer here. So just to focus on the slide that we have up here, we've talked about the Personal Health Information Protection Act. We've talked about the need to ensure that the patient, that the member has a form advising what they can disclose or cannot disclose. And it's important to note that sometimes a patient might have no problems with their general physician or family doctor knowing. And it would be important, I would suggest, in your form to ask the patient that, am I allowed to share any information with your other healthcare practitioners? Because there may be certain situations where the patient does not want. Again, patient-centered focus. So it'll be important for you just to not assume that you can share information with the family physician. You're going to want to ensure that the patient has consented to that. And again, the Personal Health Information Protection Act permits in certain situations for patients to tell their TCM practitioner, I do not authorize you to share this with my GP or my homeopath or my dentist. That might sometimes occur. So back to clarity, you will want to have clarity to see who you can in fact disclose this with.
And I guess this is a very important piece of information or an important document to have, especially if your patient has insurance coverage and the insurance calls you and says, I see that this person had made a claim and we're just double checking on the claim. Would you be able to tell me if they came to you on this date? So this is a really, really good document to have on hand so you are able to share that information. Can you elaborate on that?
Yes, if we go to the next slide, this slide kind of talks about situations that once you have that signed form, right? Once you have that clarity, and I will pause, if your form doesn't address the question you might have, you might need to go back and ask the patient. So for your scenario, Amy, if you have a signed form and everything looks great, and suddenly the patient's insurer calls up and says, we want all the patient files for this patient because she has submitted a claim. And you might look at your form and say, I don't know if maybe I didn't ask this. I don't know if I have the patient's consent to disclose this information. So if you are ever uncertain, it's really important you go back and you ask the patient. Now, in my experience, insurers will usually send you a form because most people to get insurance have consented to this, have set out in writing, I consent to my healthcare practitioner sharing my records with you. So insurers will usually be able to provide the consent of the patient because the patient agreed to that in order to get the insurance. But in any other scenario where if you go back and you look at your form and you're like, I don't know if I have consent to do this, they're gonna you can go back and ask. But I do want to alert you that there are going to be certain situations where you do not need to have consent. Okay.
So that was my next question.
Okay. Sorry. I'm jumping ahead. So
That's okay.
Even in the insurer situation, if it's not on your form, it might just because it's not on your form doesn't make it absolute. The insurer might provide you with that consent. So great, you have consent. But Again, if there is a circle of care, so remember we talked about the GP, and most times people have no concern about sharing it with their GP because the GP might have referred and suggested that the patient goes to see you. So that there's an assumption there that the legislation said that, and it's called a circle of care. That would be fine. It's only when the patient says, don't share it with my GP, that you can't. Sometimes you'll be served with a legal summons. Sometimes a lawyer will show up or a police officer will show up with a warrant and saying you need to hand that over. You don't have to and actually can't say, no, 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 I can't disclose this without the consent of my patient. No. Personal health information is very important, but there are certain situations, legal situations, if you're provided with a summons, you'll want to carefully review it and make sure you comply with it. The other situation, and we see this quite a bit at the college, is that sometimes members are so vigilant in keeping their patient information confidential that if a college investigator comes and attends at the clinic, or if the quality assurance committee has asked to see certain records, the member will say, no, I can't do that. And the members should be feel safe and confident that when the college asks that information, they do so pursuant to legislation. The legislature has allowed the college to go and take records when necessary for an investigation or when necessary for a QA process. So in those situations, patient consent is not needed. The college will keep that information confidential, of course, but there are certain scenarios where members do not need to have express consent from their patients. But if they are confused and they're not sure, they should ask, okay, you're telling me I don't need consent. Please show me where. That's totally appropriate. And the college in that situation should say, great question. Here is where it says you don't need consent. Or the police will say, here is where it says that you don't need consent. Okay?
Perfect. So just to conclude with Principle 5, with our next slide, the record keeping part of it. How do we document all of this information?
Great question. So again, you can either have, this might be a situation where having a form in advance, setting out a couple things. A, advising the patient what you're going to be using that information for, right? So first of all, collecting. That saying you're collecting information to assist with their health care. So you're going to want to ensure you only ask for information on your forms that you actually need, right? You shouldn't be asking information that you don't need because that could be breaching the act. Only collect what you need. And then the second thing, advising patients, this is how we're going to use your information. We're going to use it within our office, right? We're going to be we will never disclose this unless we have your consent or we have to pursuant to some other law situation. So letting the patient know how you use it. And then C, saying this is how we will disclose it. We, again, will only disclose it with your patient, with your consent, or if we have to because of the college or because of the police. So you can provide that information up front to the patient, have them sign, ask them, is there any carve-outs? Are there any health professionals you don't want us to share this with? Because we assume that we can share them with your health professionals, but you let us know if you don't want that. So you could put this in a form. You could provide this. I would suggest that this is one of those that they probably could sign it in advance before they show up, but you want to review it with them. You'd want to go over them to make sure and then, either check it, which indicates you've gone over with them, or indicate in the chart, I've reviewed that with them. Because remember, personal health information is very important. It's very sensitive. So you want to make sure there's clarity between you and the patient is how it will be collected, used, and disclosed.
Perfect. Thank you. I know that we have a lot of questions, but I'm not sure if we have the time to go through all of the questions.
We turn to Anya. Anya, you're our boss here.
I'm going to turn it over to Anya.
Thank you, Rebecca and Amy. This was great. I think we can probably go ahead and continue with the questions. We've received some really good questions. And I know we have some FAQs as well. So I suggest that perhaps we go ahead and answer at least a few questions.
Okay, great. So I've tried to compile some questions for myself that I've run into in my clinic, and it's really nice to have you here, Rebecca, to be able to clarify some of these for us. So let's say I work in a multidisciplinary clinic. Should we have a different version of consent forms for each practitioner?
So if we're talking about consent to treatment forms,
Mhm.
I would say probably, because of course, remember, one of the components of consent to treatment is the nature of the treatment. So if the nature of the treatment varies between a homeopath, a naturopath, an acupuncturist, which it likely would, then that would require an individual informed consent discussion, which then could be indicated by a separate informed consent form. So I
Mhm.
understand the desire to sort of avoid duplication. That's not in the patient
Mhm.
doesn't want to be signing a million forms. But getting back to what the point of a consent to treatment form is to evidence, is to prove that the informed consent dialogue occurred. So if it would be quite difficult if a patient who, let's say, came to the clinic on January 1st, filled out a general form, saw their massage therapist, then on April 1st went to see an acupuncturist, and the acupuncturist relies on that consent to treatment form because time has passed, different treatments going to occur. The risks of acupuncture will be different than that of massage. So all of the components are of informed consent are distinct. So I would suggest, again, if you're working in a if there's a common consent form for perhaps for disclosure of information, that might be
Mhm.
common. But on the
Right.
actual treatment, that would not be evidence of informed treatment.
Right.
You'd want either an individual form or an individual discussion amongst the various practitioners.
And that goes back to, what we discussed about the patient being informed, right? And the patient knowing what they're going to be putting their
Exactly.
body through, and to open up those communication lines where they have given you full consent for what you're about to do
Exactly.
with each individual. Okay, great. If I'm treating a patient for pain issues, do I need them to sign a new consent form if I will be making changes to their current treatment plan? So let's say
Yes.
they came in for back pain
Yep.
and now they have a headache.
So there you go. So the short answer is yes. Again, so the new consent form will be signed after the dialogue. So what we really want to drive home here is that yes, the forms will be signed, but the form isn't the informed consent. The informed consent is the dialogue. So if you have a patient coming in for back pain initially, that's been treated, and then you're advised by the patient, I'm also having headache pain. So if that's going to require a different course of treatment or an additional course of treatment, the nature of the treatment has changed. And if the nature of the treatment has changed, then there may be some risks. There may not be, but if there are any, the nature of the treatment has changed, that's a trigger that a new informed consent dialogue needs to occur. So,
Mhm.
whether it's a full form or even documenting in the patient chart, the
Yeah.
patient came in for back, has advised of headache pain. We discussed what the new additional nature of the treatment would
Mhm.
involve, any risks. And you would indicate this, and the patient consented.
And
That
that would
is,
be that expressed consent,
you
right? You've
got it.
had the
You
dialogue,
got it.
you've spoken about where you're going to be placing the needles, you've expressed the risks, and you're expressing consent, or the patient is giving you expressed consent because we've
I would
spoken
agree.
about it.
I would agree. And again, I would rely upon the practitioner. If I just don't think necessarily saying, oh, well, if it's acupuncture, then it's a general, because of course, acupuncture, depending on the body, and I would obviously defer to you, Amy, but I'd say, there are different, it's not proper to say just simply acupuncture, different treatments of acupuncture, there's different purposes of acupuncture, different sizes of needles and body parts. And
Mhm.
each, I would assume, have different levels of risk. So back to
Right.
that patient-centered, right? To simply say, I think that doesn't really reflect the nuances of the profession.
Right.
And it's really important for the patient to be fully aware of what's going to happen.
Mhm. Okay, great. Let's say some patients are not comfortable with signing the consent to collect, use, and disclose personal information form.
Mm.
What do we need to do
Okay, great question.
instead?
So if, remember, the form is going to be evidence to you that the patient consents to the use, collection, and disclosure of information. So if they say, no, I'm not going to sign this at all, I'm not going to consent, I'm assuming practically they probably have no problem with you collecting information, but they're probably saying, I don't consent to you ever disclosing information. So if
Mhm.
they say that, and you get a request from a third party saying, hi, we'd like patient X's charts. What you would say in that situation is saying, sorry, I don't have the consent of the patient to do that. I asked them in certain situations, they've said, no, I don't. So in order for you, insurer, to obtain, or in order for me to disclose this information, you need to provide a consent to me from the patient.
Mm-hmm.
So you need to be mindful of what authority have you been given by the patient. And if the patient hasn't given you that authority to disclose, and if it's not one of those scenarios where you don't need consent, like disclosing to the college or the police, if it's an insurance company or another health professional, you need to say, I can't share this without consent. They have said they won't consent. So you need to provide that to me before I can disclose. And again, my experience usually will be that the insurer will provide you with the consent from the contract of insurance, or if the third party is another provider, they will reach out to the patient. The patient will go, oh, okay, fine, I'll sign a form and allow Amy to disclose it.
Right.
But you always want to be mindful, what authority has the patient given you? And if it's not one of those automatic provisions that allows you to disclose, you can't and shouldn't disclose until you have that written authority or that authority from the patient.
That's a really, really good piece of information, because often it does happen, and we want to make sure that we're protecting our patients' privacy as much as possible.
Exactly.
If a patient has not come to see me for over 6 months, do we ask the patient to sign another consent form?
So I'm going to sound like a lawyer again and say it depends, right? So over the course of that 6 months, remember, the first thing we always want to focus on is the patient capable to consent. And who knows, if that patient you saw 6 months ago was totally capable, mentally capable, but 6 months later you're concerned that they've come back and they don't seem capable, that's the first thing you're going to want to pause. Are you still in a position to consent to the treatment that you provided 6 months ago? So that's the first thing you want to look at. Secondly, if that's not a concern, you want to get back to that patient-centered focus and saying, okay, it's been 6 months since your last treatment. Have there been any changes in your health, any injuries, any concerns, any stresses? Because those changes to the patient might impact the treatment that you provide, right? That big chunk of time, the patient might come back and say, just please continue with that acupuncture treatment on my lower back. But if during that 6 months, the patient's had, was in 3 bad car accidents that really, really damaged their lower back, and you weren't aware of that, and your treatment might exacerbate some of the injuries, you can see. So I would suggest it's always prudent when a patient comes back, whether it's 6 weeks, 6 months, have there been any changes? Are there anything we should be aware of? You remember you consented to this treatment. Are we still okay to proceed? Because that's grounding the patient, reminding them what's, and ensuring that you have sufficient information in order to provide the continued treatment. So if sometimes nothing might change, sometimes those questions that you pose to the patient might trigger the need to go through the whole informed consent process again.
Which I think is really important, because if you haven't seen your patient in 6 months, a lot of things may have changed with their body as well. So you're going to have a brand new intake form. So I wouldn't see why there wouldn't be, you wouldn't take that extra step, right? Because you're explaining everything anyways. 6 months is a long time. A lot of things can happen. Yeah. Okay. If I need to speak to the patient's primary care provider to discuss the treatment, do I need to obtain consent from the patient? Or would a verbal consent be sufficient in this case?
So this gets back to principle 5 in the standard, where what permission do you have to collect, use, and disclose information? And again, the Personal Health Information Protection Act allows practitioners to assume that it can share information without express consent to the health professionals involved in the patient's care. That makes sense. That should be able to be shared. But back to that carve out that the legislation provides, it does state that a patient is permitted to opt out of that circle of care sharing, that the patient is able to say, no, don't disclose it to Dr. X or Nurse Y. So if you do need to speak to a patient's primary care provider to discuss a treatment, I would suggest go back and see, did the patient identify that you aren't allowed to discuss it to someone? Okay, did the patient consent to you disclosing things to the people that they share, that they go to? So that'll provide you back to, remember, you always want to say, do you have sufficient information? Practically though, I would suggest, if you do need to speak to a patient's primary care provider, that probably would have, that realization might have occurred during the appointment with the patient. And it's great practice just to touch base with the patient saying, okay, I think it'd be prudent if I do call your doctor. Is that okay with you? And if the patient says, yeah, that's fine. It's not a whole form that needs to be filled out. Then you would just say, oh, I discussed with the patient about calling Dr. X, and patient was fine. So that it's giving evidence of that dialogue you had, and it really wouldn't take any extra time. So whenever there's any ambiguity, go back and clarify.
Well, I do have some patients in the office that are taking Western medication, and maybe they're taking it differently than prescribed. And then they have side effects with this medication that might be affecting my treatment. So it's important to sort of have that dialogue with the family physician to say, could this be something that we could both look into? Because that information for everybody to have, you're actually looking out for the best interest of your patient first and foremost. So that goes through all of the principles of 1 through 5. So yeah, that's really good. I'm working at a clinic, and I've taken over the care of patients for a practitioner that is retired. For the previous patients of the clinic, am I required to get written consent to collect of information from them if they already have forms on file? What about the consent to treatment? So there's two things there.
There's two there. You got the two consents, right? The consent to collect, use, and disclose information, and the treatment. So I would say, again, without sounding too lawyerly, if you have taken over the care of patients for a practitioner, and that practitioner already had the information form signed, I would suggest it's probably good practice to then bring in a new form, because you are someone new. So you will be using information, not the previous practitioner. So it's going to provide clarity, and it would seem somewhat obvious, but I would suggest it's just a great practice to not only introduce yourself to members of the practice, patients of the practice, but reminding them this is how you are aware of your use, collection, and disclosure obligations. And remember, not casting any doubt on the previous practitioner, but maybe the previous practitioner's consent form to collect, use, and disclose information wasn't in compliance. So to rely upon a form that maybe was not in compliance wouldn't be great. So I would say use this opportunity to refresh and ensure that all the patients are aware and reminded of what you will do to collect, use, and disclose. And again, on the consent to treatment, the form is not the informed consent per se. The form is just evidence of the dialogue that would have occurred in this case between the previous practitioner and the patient. So my advice would be you shouldn't really rely on that signed form, because times probably have changed. There might have been some passage of time, and you want to ensure that you are aware and have answered any questions the patient might have. So a different practitioner can really, you might have a different approach, you might have different techniques. So you can see back to the patient. It would be in the patient's interest to stop, have that discussion, have that dialogue, have another form then signed, because it would be in the patient's interest, and it'll provide you with reassurance that you have informed consent, not the previous practitioner. You have consent to provide that treatment.
Great, thank you. That's amazing. I learned a lot today, and I'm really, really happy that we got to have this conversation.
And I learned a lot too. I can talk about legal stuff, but the practicalities of the profession, I always learn so much from you, Amy.
Thank you.
Oh, I think you're muted, Anya.
I was muted. I'm sorry about that. Well, this really was great. Thank you so much, Rebecca and Amy, for sharing your knowledge with us today. We apologize for the timing, but this is such an important topic. We ran out of time and couldn't answer all the great questions that we received. We will address these questions in our FAQs, which will be posted on our website in a few weeks. Also, as a reminder to our members, the webinar can count toward your professional development activities. We will be providing certificates of attendance to those who were able to join us today. The recorded webinar will be available on the college website in a few weeks as well. Also, please be sure to complete our survey, which will be emailed to you after the webinar. Your feedback is really, really important to us. Again, we hope you enjoyed the session, and thank you again for attending. Have a wonderful weekend, everyone. Bye-bye.
Thank you. Bye.